Welcome, everyone, and thank you for joining us for today's program, The Latest Trends in Middle Market M&A. My name is Rakesh Parikh, and I'm a senior associate in the corporate section at Williams Mullen. And I think our slides haven't moved over. We can advance the next slide. Thank you. And I'm based in our Richmond office. I focus my practice on mergers and acquisitions, corporate reorganization, corporate formations, corporate governance, and security offerings. I've experience advising on IP, technology, insurance, finance, and general regulatory matters. Today, I'm joined by my colleague, John Bliley.
Hey, good morning. My name is John Bliley. I'm a partner in our corporate section based out of Richmond as well. I focus my practice on M&A, securities, and other sort of commercial transactions.
Great. We'll kick off our program. Before we do, I have a few housekeeping items to go over. At any point during the presentation, feel free to submit questions in the Q&A button at the bottom of the screen. Time permitting, we'll address those questions at the end of the presentation. If you're having any audio or technical issues, please use the same Q&A, and our marketing team will make sure you get resolved. And then also, finally, don't worry about taking out notes or anything. We'll send you a copy of the presentation materials and a link to the recording by email after the program. All right, next slide. Thanks. And John, I'll pass it over to you to talk about risk allocation between buyers and sellers.
Great. Thanks, Rakesh. So this morning, I just wanted to touch briefly on sort of what I'm seeing in terms of risk allocation between buyers and sellers in M&A transactions. We're seeing a continued move away from traditional indemnification and escrow holdbacks to sort of address breaches and reps and warranties. That's nothing new. There's continued widespread use of RWI, that's rep and warranty insurance, to sort of cover that gap. Just as a quick primer for those who may not know, that's just shifting the risk to a third-party insurance provider where there's a breach of a seller rep warranty. Under that structure, it's basically a synthetic indemnification that is allocated to a third party. Maybe the buyer, the seller, retains the deductible or retention, as it's called under the policy. So none of that's new from what I've seen, really. But what I thought would be interesting to talk about today is sort of the way that different transaction structures are used in your purchase agreement to implement an RWI structure, and sort of how leverage between buyers and sellers can sort of impact the structure that you use. So if we go to the next slide. So the first structure that I've seen become popular is a full walkaway structure, also known as public style or a no survival deal. And in this structure, none of the seller's reps and warranties survive closing, and there's no indemnification mechanic or provision in your transaction agreement. And buyer's sole recourse would be to make a claim against the RWI policy, except typically fraud claims would be carved out of that no recourse. And under this structure, the buyer would pay the full retention or deductible under the RWI policy, and the seller just kind of walks away clean. The second one that I've seen recently is kind of a hybrid of this, and that's where the buyer and the seller split the retention deductible. So in that structure, it's the same general concept as the full walkaway, where no reps warranties survive closing, except here, typically half of the retention under the RWI policy would be held back as in an escrow for a certain amount of time. And typically 12 months under most RWI policies. There's about a 12-month window after closing before the retention under the policy usually decreases by about 50%. And so your escrow would be tied to that, and it would be released at that period, less sort of any claims made. And under this structure, the buyer typically absorbs the first half of the retention, and then once that is satisfied, then they could go after the escrow to cover the balance of the retention under the policy. And oftentimes, where there's a breach of a fundamental rep, typically authority, title to assets, non-contravention of certain matters, and tax items. If it's a breach of one of those types of reps, oftentimes the buyer would go after the seller's retention escrow holdback first for those claims. And then on the next slide, there's two more structures that I'm seeing. Another one is where only the fundamental representations survive closing. Here you have, as I just described, the fundamental reps survive closing, but the non-fundamental reps do not survive closing. So it would be the same general structure as I described above for a full walkaway as it relates to non-fundamental reps. But the difference here is that the buyer would have a traditional indemnification right, and there would be a traditional indemnification provision in the transaction agreement that addresses indemnification for fundamental reps. And you would have survival periods that you would typically see for fundamentals, be it 6 years, statute of limitations, or and sometimes an indefinite amount of time. And then the final structure that I've seen is really kind of an older structure, but I'm still seeing it used. And that's where you have a traditional indemnification mechanic with a full provision that you would typically see in a purchase agreement. The rep and warranty insurance policies is sort of contractually set forth as the first source of recourse. And so under that structure, as you would typically expect, all reps, fundamental and non-fundamental, survive closing for your typical survival periods. For the non-fundamentals, 12, 15, 18 months, and for the fundamentals, 6 years, statute of limitations, indefinitely. And then so the buyer would have traditional indemnification rights, and then you'd have your standard caps and baskets and deductibles and the like. And typically in that structure, the deductible would be tied to the retention amount under the RWI policy, and there may be a split kind of the deductible retention as described kind of in the previous section. And then if there's a final claim under that indemnification provision, the rep and warranty policy would be sort of the initial recourse that is the RWI is sort of the initial recourse, and to the extent that a breach of a rep warranty isn't covered under the policy, the seller would be liable for the rest of the claim, obviously subject to the caps and whatnot.
Thanks, John. In terms of negotiating strategy, because that's really what it comes down to when you're negotiating these structures, when would one expect to see any one of the four structures you just discussed? Also, what buyers, if any, may shy away from RWI coverage?
Yeah, great question. So the structures really depend on leverage. And on this slide, I kind of lay out what you might find under the certain circumstances. So, if you're in a highly competitive auction process, the seller has a lot more leverage than the buyer does typically. And in that structure, I've seen the sort of full walkaway structure has kind of become the standard. The buyers are trying to differentiate themselves and set their best foot forward, and so they're willing to sort of accept some of the risks that go into the full walk structure. And then the other three structures I described, I would say are in situations where the buyer wants to be competitive, but there is a little consternation about the seller not having skin in the game, and maybe not being as diligent with their disclosure schedules or review of the reps and warranties, because again, their sole recourse is claims for fraud, which usually in these agreements is tightly drafted to sort of be the highest level of fraud, sort of intentional just failure to disclose something. And so in these other structures, there's a level of the seller having more skin in the game because there is potential post-closing liability. And I guess the first is sort of where the fundamentals survive only. I would say this is sort of the next level of seller-friendly structure, because if you think about it, one doesn't typically think of a fundamental rep being breached. And so there really isn't a whole lot of risk on the seller, unless taxes are included in fundamental reps. But in that case, it's still really about net zero, because under most structures, the sellers has a $1 pre-closing tax liability anyways. So I would say the fundamental survival structure is still very seller friendly, but does at least give them the skin in the game of having something surviving. I would say the next one is where the retention is split 50-50. In that structure, at least the seller has a financial exposure in the indemnification structure, simply because, if there's a non-fundamental breach of rep, it's very possible that at least their half of the escrow for the retention amount would be used. And so here, I would say that's maybe slightly less seller favorable than the fundamentals surviving only, just because there's actual, real risk that a non-fundamental rep would be breached. And then I guess the third would be the traditional indemnification, where RWI is the sort of initial recourse. Again, here the seller has the benefit and the protection of the RWI policy, which for the most part would cover most breaches of reps and warranties. And it also, in this structure, would give the buyer the comfort knowing that they have all of the traditional indemnification rights in the event that something isn't covered by the policy. And then I would say that strategic buyers may still be reluctant to rely on RWI, but that isn't necessarily true in all cases. It depends on the circumstances. If there is a heated auction where a strategic and a private equity backed company are sort of both bidding for a target, a strategic buyer may have no choice but to sort of go with an RWI based structure just to sort of stay competitive. And again, I would also say that you would that there is a sort of a transaction value threshold under which RWI may not make economic sense, and typically anything less than 30 million, in my experience, has been kind of the threshold. But depending on how hot the RWI market is, the premiums and underwriting costs may still work for deals that are smaller than 30 million, but it starts to get a little less just financially feasible.
Thanks, John. That actually concludes our presentation today, but it looks like we might have time for one question. Just looking down this list. John, in your experience of deals that you've worked on, the ones that are RWI relevant, how much have RWI involved?
I mean, in every one of my deals, that, as I sort of use that $30 million threshold, every one of them has had RWI, and every one of them has had a different one of these iterations that I've just sort of described in terms of how they implement the structure mechanically. So again, I would say it's prevalent, and it's a great resource to sort of save the seller the hassle of post-closing indemnification, the hassle of the escrow holdback, and it gives the buyer a really strong source of recovery for any post-closing breaches.
Fantastic. Well, everyone, thanks for joining us today. It looks like we're out of time. If you asked a question, we didn't get to it, we'll reach out to you directly. But feel free to reach out to us. Our contact information is here. But otherwise, have a great day.
Thank you.